Our weekly immigration news roundup is brought to you by the law firm of Figueroa and Associates. For consultation on any immigration or legal matter, please call 855-768-8845. That's 855-768-8845. For full stories and more immigration news, visit www.theimmigrantsjournal.com. That's www.theimmigrantsjournal.com.
Hello, my name is Mary Campbell, legal assistant at the law firm of Figueroa and Associates, and your presenter with this week's immigration news. We begin with Supreme Court's Munoz decision disregards fundamental interests of U.S. citizens married to non-citizens. In Department of State v. Munoz, the Supreme Court has chosen procedural concerns over the reality that errors by consular officers may bar U.S. citizens from residing in the United States with their non-citizen spouses. Consular non-reviewability is a judge-made doctrine. Courts have board review of visa denials due to separation of powers concerns that decisions about admitting or excluding non-citizens may raise foreign policy concerns and should be left to the political branches. In 2015, the Supreme Court in Kerry v. Inn left open the question of whether a U.S. citizen spouse has a protected liberty interest in their spouse's visa application. 4 justices concluded that no constitutional right existed, but added that even if there were, the U.S. citizen spouse had received due process. Justice Kennedy's concurring opinion, joined by Justice Alito, assumed a constitutional right existed, but agreed that the process satisfied the Due Process Clause of the U.S. Constitution. Supreme Court allows deportations without adequate notice, backtracking on previous rulings. The Supreme Court made an about-face on June 14, holding that immigration judges may order non-citizens deported if they do not appear for their immigration hearings, even if the government never provided them with a notice to appear with the date and time of their immigration hearing. Under Campos-Chavez v. Garland, so long as the government provides a second notice with a hearing date and time, sometimes months or years after the initial faulty NTA, a person can be ordered deported in absentia. Under immigration law, a non-citizen can be ordered deported if they do not show up to their immigration hearing, but only if they receive proper notice. And if a non-citizen is ordered deported in absentia, they can move to rescind that order if they can show they did not receive such notice. Immigrants are key to filling U.S. labor shortages. New data finds almost 1 in every 7 people in the United States is an immigrant, according to the American Immigration Council's new analysis of the 2022 American Community Survey. The updated state-level data from the Council's Map the Impact tool reveals how immigrants, including those who are undocumented, make crucial contributions through their work in vital industries, starting businesses, and paying taxes. In 2022 alone, immigrant households paid $579.1 billion in total taxes, nearly 1 in every 6 tax dollars collected by federal, state, and local governments. Meanwhile, in NYC, New York City doubles debit card payments for migrants. New York City is broadening its initiative to issue prepaid debit cards to migrant families residing in hotels, enabling them to purchase food and essential items. City officials anticipate distributing 7,300 prepaid debit cards over the next 6 months, totaling over $2.6 million in value. Currently, the city is responsible for more than 60,000 migrants, and the program will expand from 3 hotels to 17, potentially aiding 1,230 migrants monthly. Members of elite Haiti force lost in New York as asylum seekers and parolees. Haiti is likely one of the most dangerous countries in the world to be a police officer. Amidst the ongoing violence and political turmoil in Haiti, the police force has experienced a decline in its ranks. And like thousands of Haitian immigrants in the United States, some of Haiti's highly trained officers have left the country to live as asylum seekers in New York. They now find themselves disoriented in a system they barely know, struggling to redefine their new lives. In other news, DAS extends and redesignates Haiti for temporary protected status. On June 28, the Biden administration announced that temporary protected status, TPS, for Haiti will be extended for 18 months, effective from August 4, 2024 to February 3, 2026. Secretary of Homeland Security Alejandro Mayorkas also designated Haiti for TPS, allowing Haitian nationals already residing in the United States as of June 3, 2024, to apply for temporary protection and work permits. Currently, over 200,000 Haitians with TPS live in the U.S. The Department of Homeland Security's decision will provide an opportunity for approximately 309,000 additional eligible Haitians to reside temporarily and seek legal employment in the U.S. without concerns about deportation. The AAS justified this decision based on ongoing gang violence in Haiti, which has led to violence, insecurity, and severe limitations in access to safety, healthcare, food, and water. Justices to review relief for self-deportation failure. The U.S. Supreme Court has agreed to review whether noncitizens who do not depart voluntarily within 60 days of a deportation order can seek to reopen their removal cases when the 60th day falls on a weekend or federal holiday. Immigration attorneys cautiously optimistic after Chevron ruling. Immigration lawyers are cautiously optimistic following the Supreme Court's Chevron ruling, which states that courts are no longer required to defer to federal agencies' interpretations of unclear laws. This decision could aid immigrants contesting removal orders and potentially safeguard executive immigration actions from partisan legal challenges. IT workers say Chevron's end dooms spouse work permits. Former IT workers conveyed to the D.C. Circuit that the recent U.S. Supreme Court decision, which overturned long-standing precedent on judicial deference to federal agencies' interpretations of laws, strengthens their challenge to an Obama-era program permitting work permits for certain spouses of highly skilled foreign workers. Finally, CBOES, 1 year after its implementation. Approximately 1 year ago, U.S. Immigration and Customs Enforcement, ICE, launched Cash Electronic Bonds, CBONDS, a web portal with the stated intent of improving how people pay bonds to ICE to secure the release of a loved one from detention. 1 year in, it's clear that while CBONDS makes it easier for some to pay bonds, it presents serious complications for others. Thank you.
Our weekly immigration news roundup is brought to you by the law firm of Figueroa and Associates. For consultation on any immigration or legal matter, please call 855-768-8845. That's 855-768-8845. For full stories and more immigration news, visit www.theimmigrantsjournal.com. That's www.theimmigrantsjournal.com.